Hey everybody, Paul Rabelais here, another live stream, and this one's about estate planning for parents with minor children. So I can certainly relate. At one point in my life, my wife and I had five minor children, had them all in about a 9-year period, and but like most, we survived that period. Now our 5 kids are all adults. 3 of them are lawyers. 2 of them are in law school. So um, lots of future Rabelais lawyers. So what I want to talk about in this live stream, it's important. In fact, I find that estate planning for parents with minor children is one of those topics that all parents with minor children have some idea that they need to do something from a legal planning perspective. But a lot of them, they just don't get around to it. Maybe it's because they feel like they're going to live forever, or at least they're going to live for another 30 or 40 years, and they can put this stuff off until later. Maybe they're busy paying for their living expenses because life is expensive these days, and they feel like that's an expense that they can handle in the future. But unfortunately, the consequences of somebody with minor children, the consequences of when a parent or parents pass away with minor children, the legal mess that's created when there is no plan is often just a lot worse than when older Americans pass away and they have no estate plan, but they have adult children. So we'll be talking about a lot, quite a bit this evening here. I'm going to divide this up into 3 parts. The first part I want to talk about is what happens if parents with minor children don't do any kind of legal planning. And then we'll move into what are some of the decisions, or what are all of the decisions that parents with minor children need to make in order to put the right plans in place. And then we'll go through maybe kind of a hypothetical or a couple of them, what those plans might look like. So like we always do, if you have some questions, comments, experiences, throw them in the chat. We'll get to those after the presentation. So let's just jump right in. Number one, what happens if a parent or parents with minor children pass away? So clearly what I'll be talking about here is what happens. Sometimes you'll have a single parent, maybe divorced, and they have minor children. We'll also talk about the situation where you have a married couple and both spouses pass away and things, and now they've got minor children left behind. I've been involved in a few of these circumstances, and they're really gut wrenching. So not only just the legal and financial stuff that's involved, but just all of the emotions and all of the mental issues involved when a child loses their parents. So having the legal stuff in place sure does make things a lot easier. So all right, but first we got to talk about what happens if people don't plan. First, before we talk about what happens when parents pass away, parents who have minor children, let's first talk about how if parents with minor children, let's say parent due to an illness or injury, gets to a point where they're unable to handle their accounts, sign their name, make medical decisions for themselves. So if they don't have anything in place, so if a mother of 3 young children passes away, or not passes away, but illness, injury, is unable to deal with her accounts, transact for herself, and she hasn't put things in place to provide for that, then somebody, it might be her husband, it might be another family member if she's not married, somebody's going to have to really sue her while she's in that state of incapacity and follow all of the procedures that are required in order to become that mother's legal guardian. So that's a lawsuit against the mother. The mother has to have a lawyer represent her. One gets court appointed typically. Judges have to rule that the mother does not have the capacity to transact for herself, so that a judge can further appoint a legal guardian for the mother. So now that legal guardian can stand in for the mother and sell the mother's house if that's appropriate, or handle different accounts and different things for the mother. So parents with minor children not only need to cover what happens if they pass away while their children are minors. I cringe every time I think about it. But also they need to cover all that incapacity planning. What if they're not able to make their medical decisions, make their financial decisions, that guardianship proceeding is often necessary when that's the case. Other things that happen when a single parent or couple with children passes away and they have minor children, is a judge will wind up selecting a guardian who will have the authority to raise the kids until the kids reach the age of majority, which is in most states age 18. So by having no plans and no formal legal plans in place, parents are giving up that control of being able to determine who will raise their children in the event the parents pass away and can't. So again, most people realize, no, I wouldn't want to judge making that decision. I'd like to have that control, but that's the case if parents with their children have no planning in place. Another thing that will happen when parent or parents pass away and there's no legal planning in place is, I'd say virtually every state has laws that says, yes, if parents pass away and they have minor children, then if there is no legal plan in place, then the assets of the parent would go to the children. But it is a big legal mess when assets are left to a minor child. A minor, someone who's 3 years old, 7 years old, 11 years old, they don't have that legal capacity to inherit and own assets in their name. So what has to happen is when the parents pass away, there's a guardianship proceeding again, and someone is designated not only to raise the children, but also to manage the inheritance of the children, with the courts overseeing that until the minor children reach the age of majority. For the rest of this live stream, we'll just call that age 18, which it is in most states. And then on that minor child's 18th birthday, that inheritance, which a court has been overseeing up until age 18, that inheritance gets dumped into the child's lap really on their 18th birthday. So, most people feel like 18-year-olds, especially if they've lost their parents, they're not ready to handle an inheritance, handle hundreds of thousands of dollars, millions of dollars, because they might make some mistakes and really blow it and not have an opportunity to benefit from that for the rest of their lifetime. So those are some of the consequences, just some of the pure legal and financial consequences of what happens when there are parents with minor children and those parents pass away without legal planning. So now let's talk about once those parents decide, hey, we need to be proactive. We need to have our estate legal plan in place. We want to protect our children. We want to make sure that the right people raise our children. If we can't, we want to make sure that any inheritance we leave to our children will be used for the right reasons for them, for their education, for reasonable living expenses. We don't want our young children getting their hands on an inheritance on their 18th birthday. And we really don't want to judge overseeing while they're minors how that inheritance is going to be handled. Parents want to have and should have more control and more say-so as to what happens. So that's the whole idea of estate planning for parents with minor children, is to put some of that control back into the parents' hands. So some of the decisions that parents make when they make that decision to we want to do what's right for our children. We want to do what we can to make sure our children are raised right, that any inheritance is used for the right reasons. What do we need to do? So some of those decisions include parents naming guardians. Who are those backup parents? Who do the parents feel like would be best suited to raise the minor children if something happens to the parents before the children reach the age of majority or age 18? Some parents, especially the younger parents, maybe parents of a 1 and 3 year old, those parents might be in their late 20s or their early 30s. They might say to themselves, or that mother might say to herself, you know what, if my husband and I aren't able, and something happens to us and we're not able to raise the kids, it seems like those young parents often say, I'd want my parents to be the guardian of my children. So some people say some parents of minor children say they'd want their parents to be the guardian of the minor children, ultimately the grandchildren of those grandparents. Some people, it's quite often for people to designate a sibling, which is an aunt or uncle of the minor children, to be the legal guardian if the parents pass away before those children reach the age of majority. Some people say there's a friend, maybe a friend, a neighbor, or someone that they know would look after the children properly. So there's that decision on who you'd want to be the guardian, or as I call it informally, the backup parents for those minor children, if you, as a parent of minor children or parents of minor children, pass away before the children reach the age of majority. Another decision parents will make is that not only that guardian who will raise the children and have those parental rights to determine where the children live, where the children go to school, what kind of medical treatment will the children receive. The other decision parents with minor children need to make is who's going to be the trustee or co-trustees of a trust that the parents leave assets to. Because if the parents leave assets to the minor children outright, a legal nightmare, minors can't inherit. And so courts oversee that inheritance and it gets dumped into the child's lap on their 18th birthday. So it is very common for parents to say, well, if I pass away, or if we, meaning mother and father of the children, pass away, many parents say, I would want, all of my assets, all of my life insurance, all of my retirement accounts, any equity I have in the house, any savings, I would want all of that to go into a trust or trusts for my child or for my children. And that way, if it goes into a trust for the children, then you get to select who's going to be the trustee of that trust, and you're going to select what those assets can be used for during your minor child's the remainder of the time that they're minors, well into their young adulthood, and maybe even beyond. We'll go into some of that. Well, let's go into it right now. So I'll also say it's really common for a divorced parent to, and I'm going to be blunt here, a divorced mother who has maybe 3 young children with her ex-husband. A mother might say, you know what, Paul, or you know what, Mr. Rabelais, I want to make sure I do have some assets, but I want to make sure that if I pass away, that my ex-husband never gets his hands on a penny of my money. So if that divorced mother doesn't have any plans in place, yep, you can betcha the ex-husband, parent of her children, will be the one who gets their hands on her money as the guardian for the minor children. But a divorced person, for example, like in our case, that divorced mom of 3 who has an ex-husband and they don't get along too well because that ex-husband is very irresponsible with money, that divorced mom would set up an arrangement so that if she passed away, all of her assets would go into a trust for her 3 children. She'd specifically name people other than her ex-husband as the trustee of that trust. That way her ex-husband can never get his hands on the money. And then we'll talk here in a minute about when the children can have access to the funds. So real important for people who were divorced but had children together to have those estate plans in place, perhaps to prevent that ex-spouse from having control over money that maybe you wouldn't want them to have control over. So when we talk about leaving assets to minor children through your estate planning documents, which might be your will, which in your will, you might have what's called testamentary trusts, which say, when I pass away, I leave my assets in a trust for my children. The provisions of that trust are incorporated into your last will and testament. So it's called a will, which includes a testamentary trust. Or you might have your living trust, because assets that you transfer to your living trust during your lifetime avoid probate, makes it easier to settle things. And in your living trust, you might say, when I pass away, I want my assets to go into a subtrust of my living trust for the benefit of my children. So that's just some of the terminology. But let's talk for a minute. It's some real strategic decisions, often not thought about enough. what should parents say as insofar as when children would be entitled to control their inheritance? There's a lot of different options, and I've got some thoughts on that. So let's say as you're making decisions here, you're presented with, okay, if you and your spouse pass away, you've got three young children who are 1, 3, and 5. I ask you, who would you want to handle the inheritance for them until they're old enough? We'll talk about what old enough means here in a minute. And maybe they say, you know what, my wife's sister, Alice, she would be the perfect trustee for our children to handle our children's inheritance. So they got that pick selected. They may even say Alice, and they'll say something like, well, if Alice can't do it, we want this person as a backup, and maybe even another backup to that. So those parents, they nailed the trustee selection. That mom and dad said, we've got three children, 1, 3, and 5. If we pass away, I want Alice to be the trustee of what we leave behind for our children. Maybe in addition, Alice, they also named Alice as the legal guardian to have those guardianship rights to address things like where the children live, where they go to school, how they get medical attention. Sometimes parents say, I feel I have so much confidence in this person. I want to name them both as the guardian if something happens to us, so that they can have those parental rights. And I also trust this person so much that I also want them to be the trustee of this trust, which manages assets for my children after I pass away. I'd say maybe 50% of the time, parents choose the same person to be the guardian of the minor children and be the trustee of the minor children's trust. Sometimes people like the idea of separating that. Yeah, if we pass away, we have our three children, 1, 3, and 5. We would want this person to be able to raise our children and have those parental rights, but we would want this person handling the inheritance that we leave behind to our children. So it's just a personal decision there. But let's say that decision was made. The parents said, Alice is perfect. Alice manages money better than we do. So if something happens to us, meaning the mother and father of the children or both parents, then Alice would be that trustee of either that last will and testament testamentary trust or that living trust subtrust. So my question to them would be, at what point, how long would Alice need to handle this money for your children? Let me give you some options. All right, so let me just throw out a lot of the options that we see. The first option is the children receive their inheritance at a certain age. For example, parents might say, well, when we pass away, we want Alice to be the trustee of our children's trust. Alice has the authorization to use those assets when our children are any age for our children's health, education, maintenance, and support, the typical HEM standard, HEMS, health, education, maintenance, and support. So Alice, even if the children are 9, 12, 15, Alice would have the authorization to use that child's assets, those child's inheritance or trust funds for needs of that young child. But then at what point can the child say, you know what, my parents set up a trust and I've reached the age where I'm entitled to it? And so is that age maybe 25? I'd say if there was one age that parents selected more than others when it was set up for the children to get it all at one age, I'd say most parents select 25. I've seen people say 23. I've seen people select 21. I've seen people select 30, 40, 50. But that's the first option. If you're parents with minor child and you're trying to figure out at what point should we let the children control their own inheritance. And so one option is an age. You select that age. Another option is you state that they can get it in stages. So when it's in stages, I'd say the most common that I've seen is we pass away, mom and dad. Alice is the trustee of our children's trust. Our children are 1, 3, and 5. Alice can use the assets for our children's needs at any time. However, this is the stages part. Maybe the parents say, well, when our children reach the age of 25, they can have 1/3 of their inheritance. When they reach the age of 30, they can have one half of the remainder. And when they reach the age of 35, they can have the remainder. And that the way that math works, they get it kind of in thirds at 25, 30, and 35. Does it have to be those ages when you select stages like that? Of course not. It doesn't have to be. It can be there's no limit on what it can be. You could say 25, 30, 35, and 45, or 30, 40, and 50. Some people will put certain standards that are tied more than just to an age. When our children graduate from college, or when they reach the age of 30, whichever first occurs. And so you can tie that into education or graduation or other things as well. We tend not to get too complicated, because you never know what their future circumstances are going to be. So we talked about parents saying, let's let them have it at a certain age. We talked about in certain stages. There's another one that can be popular. Maybe those parents are saying, you know what, there's nobody other than my sister Alice who's going to really know what's in our children's best interest. Our children are 1, 3, and 5. We have no idea how they're going to turn out. Are they going to be responsible at 25? Are they going to have other issues where we really don't want them getting a chunk at 25 or 30 or 35 or 40? So oftentimes, to be safe, parents will say, yep, when we pass away, everything goes in a trust for our children. Alice is the trustee. As far as how long that trust will last and when our children will get it, we're going to let Alice determine that. We're going to let that trustee have the discretion, have the complete discretion to determine when our children are old enough, mature enough, responsible enough to be able to handle inheritance. That way, Alice can say, wow, I'm the trustee over the trust for these 3 children. One of them is now 22. They've graduated from college. They're on their way to medical school. They've made every good decision they can make. You know what? I'm going to let them have their share. This other one, though, is 26, and they've made every bad decision that they can make. There's no way, Alice says, I'm going to turn over the 26-year-old share to the 26-year-old. Alice says, since I have the discretion to determine when they get it, I'm going to hold on to the 26-year-old share, make them prove themselves before I kind of turn funds loose over to the 26-year-old. So trustee discretion is another option. Another option, we see this sometimes when maybe the children are older. They've either proven themselves or really disproven themselves. And the parents are like, you know, at no point would we feel like a big chunk. Even if we divided it up into thirds, you know, if they got $500,000 in one shot, and then another $500,000 5 years later, and then another $500,000 5 years later, they blow it. So what some parents do is say, I want to set it up so that when we pass away and we leave things to our children, at least once they're a young adult, let's set it up so that our children get a monthly amount. And they might say, I think maybe $3,000 or $4,000 or $5,000 would be an appropriate monthly amount that our children should get out of their share, at least, you know, at least until it runs out. You know, if we leave this child assets worth $600,000 and we leave them $5,000 a month, maybe it'll last for their lifetime, but it will last at least until it runs out. That way the child never got a big chunk. And maybe that trustee does have the discretion to use assets for the child, or distribute assets to the child for their health, education, maintenance, and support over and above that $3,000, $4,000, or $5,000 monthly figure. So that's kind of monthly figure is another option to provide. In fact, when we use the monthly amount, we can also set it up so it's adjusted for inflation. So, you know, each year they get a little bit more than the previous year. Now, I don't want to call it an advanced strategy because it's easy to do, but what we often see is parents, particularly divorced parents who have gone through a challenging divorce, they might say to themselves, you know, what we leave to our children, we want to make sure it's protected from their divorces. So the concern is if a child gets their hands on the inheritance at 25, they may commingle it with other assets they have with a spouse. And if the child later gets divorced, the child loses perhaps half of the inheritance. So oftentimes when we set this up, we have it go into a trust for the children for the rest of their lifetime. But at some stage, maybe at a certain age, or maybe when the trustee determines the child's ready, then the child becomes the trustee of their own trust. So little Billy, who was unfortunately 5 years old when his mother or his father or both of his parents passed away, um, little Billy gets a trust, and Billy's 5 years old, and Alice is the trustee. But maybe when little Billy turns the age of 25, it's provided for that it doesn't just get dumped into Billy's lap where he could commingle it with a spouse and lose half of it if he gets divorced. It just stays in the Billy trust. But Billy becomes the trustee of the Billy trust. Now Billy controls it, but it's still in the Billy trust. And by leaving it in the Billy trust for up to Billy's lifetime, it's less likely that those assets will get mixed up with other assets that Billy has with a spouse if he does get married. And if he gets divorced, he keeps his trust, and Billy and his spouse split other assets that they may have accumulated together. So there is the concept for this lifetime trust for the child for what I'll call divorce-proof purposes. Okay, so parents have some decisions to make on when their minor children would be entitled to trust principal. That's what we just went over. Okay, so what I want to do next is move on to part 3, which is what is a kind of entire estate planning program for parents with minor children look like? So just like any other adult who creates an estate plan, whether they're in their 30s or whether they're in their 60s, that person or that couple will have what I call a will plan or a trust plan. Um, if they have a will plan, then they're leaving all of their assets in their name. In their will, they talk about how they're leaving their assets to their spouse if they're married, to their minor children. Perhaps there's those testamentary trust provisions in the will to provide for a trust that would go on after the parent who wrote the will passes away. So some parents with minor children take care of this with their wills. They leave everything in their name. They designate in their wills, they designate who they want to be the guardian for their minor children. I won't call that the backup parents. They'll designate who they want to be the trustee of the trust for the minor children. And they designate those trust terms as far as when the children would be entitled to own the assets or become the trustee of the trust, and what the trustee can use, how the trustee can use principal to or for the benefit of the children. So all that is included in their wills. In addition to their wills, those parents who have the will plan would also have these powers of attorney. Again, that covers what if a parent, illness or injury, can't sign things, can't make decisions for themselves, avoids the guardianship proceeding for the parent by the parent designating who would be able to make financial and healthcare decisions for the parent if the parent is unable to make decisions for themselves. I will say that once those parents with minor children get older in life and those minor children become adults, then it's likely that the parents will change their estate plan and perhaps name adult children in these roles as healthcare power of attorney, or listed on an advanced healthcare directive, or durable power of attorney agent. Often adult children fill these roles, but minor children can't. So you have to select other people to be able to do that. All right. Real important here. I haven't talked too much about the blended family situation. So the blended family means sometimes, every once in a while, somebody asks, what do you mean by blended family? Married couple, either one or both spouses have children from a prior relationship. So let's say the husband had a child, he either divorced or his wife passed away. So now that child is 8 years old, and then that father of the child gets married again, and maybe he and his new wife have children. So that father, it's not unreasonable for him to say, well, if I were to pass away, I want some assets carved out for my oldest child. And then me and my wife will leave, other assets to the children we had together. So that all needs to be addressed particularly in the blended family situation, because if the husband and wife pass away together, the husband's older child is not going to inherit from the husband's spouse unless the husband's spouse provides for it. So all that stuff needs to be addressed. Also, many parents with minor children, they're in that mode of trying to save, trying to start retirement accounts, starting to save for children's future education needs, save for future retirement needs. Many of those parents with minor children have life insurance. And so, maybe the husband, for example, he has a $2 million life insurance policy. And if he's married, he'll likely name his wife as his primary beneficiary, but he really shouldn't name his minor kids individually as contingent or successor beneficiaries or secondary beneficiaries. You'll see a lot of parents with minor children with the $2 million life insurance policy. They'll say, I name my spouse as the primary beneficiary. And so if the husband dies and the wife's still alive, that $2 million check would be payable to her. She's going to take care of the kids out of that. But the husband would also name a trust as the contingent beneficiary. So if his wife dies before him or at the same time as him, then those funds don't go to the minor children, which would be a nightmare, but often happens without the planning in place. But those assets would go to a trust for the children. Maybe Sister Alice is the trustee. She can apply for those benefits. And then the life insurance company would remit payment to that trust or those trusts. And Alice could control all of that until the children were older than 18, which is what the parents would want Alice to do. Another really important thing for parents with minor children to do is to document really everything that Sister Alice or the guardian or the trustee would need in the event something happens to the parents. So just as an example, we give all of our clients, we have a national estate planning law firm, America's Estate Planning Lawyers. We give every one of our clients a free online vault system where they get their own secure online credentials and they can document and make a record of everything they own, all their real estate, their bank accounts, their retirement accounts, their life insurance. Once all of their estate planning documents get signed, their will, maybe their living trust, their powers of attorney, their healthcare documents, all the appointments that they made, all that gets uploaded into their decision vault account. Maybe that hypothetical couple who have minor children, the 3 minor children who are 1, 3, and 5, maybe they make their sister Alice a user on their online vault account so that if something does happen to the parents, boy, at the click of a mouse, Alice then has every bit of information that she needs to immediately step in and take care of all of the needs of the children. So not only having all the legal documents and legal instruments in place and all the decisions made correctly, but also documenting things. You don't want to send that guardian, that trustee on a wild goose chase trying to figure out what in the heck did my sister and her husband own. I have no idea. I've got to go to all the banks now. I've got to go here, there, and yonder just to figure out what they owned. It sure would have been nice if they had documented everything in one tidy little place. So real important that that's done as well. So I also mentioned, I mentioned about 5 minutes ago that that couple could have had a will plan. I don't want to leave this topic without saying they could also have their living trust plan. If they have their living trust plan, which is really, really common, that married couple would set up their living trust. They would transfer their home, their brokerage accounts, their business, whatever, to their living trust, because if things are titled in the name of their living trust when they pass away, nothing gets frozen. No one goes through the probate process. And Alice, as that successor trustee of the parents' living trust, will be able to step right in at all the financial institutions and start managing things on behalf of the children. Okay, so with that in mind, let me head over to the chat and then we'll go from there. So Larry was supposed to have, if any of you have been on a call before, you'll know what Larry and I are good friends. I have no idea what Larry looks like. I can only imagine. But Larry and I chat just about on every one of these live streams. Larry was supposed to have jury duty today. He didn't have it. He may be called tomorrow. So good luck with your jury duty, Larry. Chuck, we almost, yeah, we kind of waited until our youngest was almost 18 to avoid the custody issue. So that sounds like that kind of worked itself out okay. So yeah, I do a lot of estate plans for people who have the 17-year-old or the 16-year-old. Maybe, the youngest child is 17 and 9 months. And I'm like, well, I feel kind of silly even asking you this, but we need to put it in there. What if you pass away and you still have children who are under 18? Who would you want to be that guardian? So we don't even ask that question if we're doing estate planning for people who don't have minor children, because all of their children are grown. So then the legal guardianship for minor children issue goes away. But glad that took care of itself. You're welcome, Tron City. That's a new name. Thank you for your comments. Jimbo, my man Jimbo, and his wife, who I've had some Zoom conversations with. And hello to you and everyone as well. Maria, most young working parents can't afford an attorney. Good point. To prepare these documents, is there a pre-printed form they can use to designate a guardian in case of death? So yeah, what you're starting to see in our technology society. In fact, I was even part of a company that was ultimately acquired, but it was a company that really targeted parents of minor children, and was set up so that parents with minor children could go online. We built the whole mechanism, and so that parents with minor children could create their documents using our tools and then go get them notarized. And so, yeah, you see, there's a lot of companies out there now that offer that as a service. And then there's the whole debate of, should people get a lawyer to guide them through us, or is it kind of good enough to use the technology and use the online companies that make this available online? So I don't really want to get into that debate, but yes, there are a number that young parents can utilize, because for many, while the 65-year-old with the $4 million estate and has pension and other Social Security income coming in, plus income off of the investments, piece of cake for them, and they know it's not always, but oftentimes kind of a one-time expense. No big deal for them to write that, $1,500, $2,000 will plan check, or that $5,000 living trust amount that eliminates all the probate expense when they pass away. They see the benefit of that. That's easy for that 65-year-old person or couple to take care of that in advance, because they know that they're really saving a lot of people in the long run. It's harder for the 27-year-old with two little kids. They're just scratching and clawing to get by, paying for diapers and bottles and housing and mortgages and student loans and food and all that, childcare in many cases. So you're right. It is tough for parents to feel like they can justify an attorney expense. So great question. Probably answered it longer than I should have or needed to. Susie Aspen, my grandson is autistic. We have no idea what is going to happen to him as an adult. I do not want his parents to be in control of his trust. So yeah, Susie, sounds like, as I read between the lines, sounds like you may want to provide in your estate plan for that autistic grandson. And it sounds like a key decision that you'd make is who would be the trustee for that grandson who's autistic, in order to make sure that the funds are used for the right reasons for the grandson and over the right period of time. Maybe that trust, if the grandson is autistic, maybe that trust would last for the lifetime of the grandson. And so lots of decisions to be made there that can really impact people for many decades to come. So good. Thank you for your thoughts there, Susie. Maria, kits are for sale, $100. There you go. DKS. Yes. Can they be challenged, or are they just as good as prepared? Tough question. There are, when people challenge things, whether they're written as a result of online forums or whether they're written by an attorney, the kinds of things that people tend to challenge are, were all of the validity requirements met? Did it have the words in there to make it a will or make it a trust? Did it have the right notary and witness requirements? All those validity requirements, they're pretty easy to meet, whether you're having an attorney do it or whether a company set up online forms. I've seen some that's mess it up, but if they're doing their job, the validity requirements will be met. And then, the other thing that people challenge sometimes is, the way that was worded. What's the interpretation of the words in that instrument? And again, that can happen to an attorney prepared plan, and it can happen to an kind of online prepared plan. Problem with the online, you're having to answer some questions, and those get automatically inserted into these documents, and sometimes it comes out funky, sometimes it doesn't. So I will say, people say, can they be challenged? Well, kind of anything can be challenged anytime. We're in America. People can sue anybody for anything. But really the question should be, if they are challenged, can they be successfully challenged? Because anything, here we are in America, anything can be challenged. Anything can be, anybody can kind of can file suit. But the question is, does their suit have merits, and will they be successful? In many cases, the answer is no, if the law is not on their side. So, Barb, how do I contact you with suggestion for an episode topic? Well, you could put it in the chat here, or put it in a comment to this YouTube. I typically look at most, if not all, of the comments on the video, so that would be a great place to put a suggestion, and then other people can chime in on it as well. Tor Ekman, you have been streaming every night. All right, man. I took last week off. My goal here is to get as many people to do what they can for their family. I was impacted in a positive way by my grandmother passing away when I was 8 years old, and it had a significant impact on my life. You say desperate. I would not say I'm desperate by any stretch. I did not get sued. My wife and I raised what were our 5 minor children. They're all grown. 3 are lawyers, 2 in law school. We're kind of empty nesters now. So I like spending this 30, 45 minutes on some evenings, kind of spreading the good news for people. So I don't really like your comment. You must be desperate, buddy. But we'll see where it goes from here. All right. Yeah. Larry, thank you for backing me up there. So, what my goal is here, also what I'd really like to see is, keep the comments positive. I do have the opportunity to kind of get rid of you. I've never used that as part of a YouTube live stream manager. So I'm going to encourage you to keep it positive. All right, and Maria's back. So I've got Maria and Larry backing me up. That is Larry, right? Yeah, that's Larry. Backing me up. So thanks, guys, and let's wrap it up. So good one here. Check my channel for ones that are coming up, and you'll have a fantastic evening. Take care. Thanks, guys.